Take a seat. We got a shocking development coming out of the United States Supreme Court. In an unsigned, cowardly 5-4 decision, the United States Supreme Court has rewarded the Trump administration from executing a secret unconstitutional plan, declaring a phony war with Venezuela in order to deport people without notice, without due process, and send them to the deep, dark, rotting jails of El Salvador. To the 5, led by Roberts, the Chief Justice, Kavanaugh, Gorsuch, and Alito, it's okay, because future people will get notice and due process rights. If they are still in the United States and stuck in someplace in Texas, they'll get their due process rights. And they completely ignore, in the entirety of their 3-page decision, what is happening to the human crisis of 250 people without due process who are deported to die to El Salvador. That's not okay. I'm Michael Popok. You're on Legal AF. This has a ricochet effect, a domino effect on a series of other cases because of this new precedent that was just set. Without the benefit of deliberation, without full briefing, without a full record being developed down at the trial court level in front of Judge Boasberg, they just reversed Judge Boasberg and said he was wrong effectively to certify a class, to order the planes to return, to order the planes to be grounded. They're okay with how the first 250 were treated, because their new ruling, and I'm going to read to you from parts of it, the per curiam, cowardly, nobody signed it majority, the concurrence by Kavanaugh, and the 2 dissents by Sotomayor and Jackson. I'm going to read to you from different places in there, but let me distill it for you. What does it mean? It means that in the future, starting yesterday, when the order came out late last night, anybody who is going to be under an order of removal under the Alien Enemies Act of 1798, under a phony war proclamation, has to be given notice that he's got to be given like a copy of the removal order, given notice, and limited due process in the form of what we call a writ of habeas corpus application. That is personal to one individual prisoner, not a group. You're not there with other people. You're in your orange jumpsuit alone with hopefully your lawyer. You bring your writ. It's asking for you to be either released from jail, released from confinement, or the Supreme Court has now stretched it and said, oh, you can ask to be let out from the removal order as well, so you don't have to go to El Salvador. Okay. First time a writ of habeas corpus has ever been used for that purpose, but okay. These have to now be individual applications, not one case in D.C., but hundreds of cases, thousands of cases now around the country, or more to the point, in one friendly jurisdiction that Donald Trump and his administration has confined these people in. Because the ruling today is that you get your writ of habeas corpus due process right to appear before a federal judge where you are incarcerated. And where you are incarcerated is not up to you. It's up to the Trump administration where they stick you. And you know where they're not going to stick them? New York, New Jersey, New England, California. They're going to stick them in red states, and the ruby red states like Texas. So they get a friendly forum. So they get a friendly appellate court back to the United States Supreme Court. The Texas two-step all over again. So for future people, including the 5 Venezuelans that brought the original case in front of Judge Boasberg, those people, they're going to get a limited due process we call the writ of habeas corpus. Individual right. Depends on who your lawyer is. It depends on who your judge is. Let's just play this out. Under this new ruling, 5-4, led by Roberts, I'm sure, let's say there's 1,000 people who are now subject to a future order by Trump to remove under the Alien Enemies Act. Okay. Each one has to get and file 1,000 petitions in 1,000 different proceedings with 1,000 different lawyers and 1,000 different hearings, all in a different cycle. Plus, even though they've said in their ruling that you can raise the issue of whether it was constitutional or not, that Trump used the Alien Enemies Act, whether it's a phony war power or not. You can raise it, but you got to raise it individually. And that means 2 judges could make a different ruling about the exact same thing. One person could say, the president did not have the power to exercise war power because we're not at war with Venezuela. And the judge right next door could say, no, I think it's fine. Then you've got conflicting petitions, conflicting results. Now you got to take a Supreme Court ruling up, and they've got to ultimately decide yay or nay about whether this was constitutional or not from 1,000 different petitions. You see where this is going? And again, it only applies to the people that are still lucky enough to have not gotten on that plane or been shoved on that plane to El Salvador. And that's the problem. Let me read to you for us. I always think the dissents are certainly more interesting than the majority opinion, which is not that long. So let me read to you from the dissent of Ketanji Brown Jackson. I think she's become the moral center of that court. It says on page 1 of her dissent, the President of the United States has invoked a centuries-old wartime statute to whisk people away to a notoriously brutal foreign-run prison. For lovers of liberty, aren't we all supposed to be lovers of liberty? For lovers of liberty, this should be quite concerning. Surely the question whether such government action is consistent with our Constitution and laws warrants considerable thought and attention from the judiciary. That's why the lower court issued a temporary restraining order to prevent immediate harm while it considered the lawfulness of the government's conduct. But this court now sees fit, Ketanji Brown Jackson writes, to intervene, hastily dashing off a 4-paragraph per curiam opinion, discarding the district court's order based solely on a legal pronouncement that one might have thought would require significant deliberation. She goes on and says, sorry about that, on page 2 of her dissent, I lament that the court appears to have embarked on a new era of procedural variability, and that it has done so in such a casual, inequitable, and in my view, inappropriate manner. At least when the court went off base in the past, or when they were wrong in the past, it left a record so posterity could see how it went wrong. And she cites to the Karematsu case from 1944, which is a U.S. Supreme Court case that's considered one of the scars on the reputation of the Supreme Court, in which they validated and allowed U.S. citizens to be put in concentration camps. Yes, we did. Italian, German, and primarily Japanese American citizens were put in internment camps because of the war hysteria around World War II. That was later seen to be probably not a good thing, nor a constitutional thing. But what she's saying here, Ketanji Brown Jackson, is at least we made a record, at least we had full briefing, at least we let the trial court do its job. With more and more of our most significant rulings taking place in the shadows of our emergency docket, today's court leaves less and less of a trace. This was 2 briefs in 48 hours, no oral argument. But make no mistake, she writes, we are just as wrong now as we've been in the past, and with similarly devastating consequences. It just seems we are now less willing to face it. That was Ketanji Brown Jackson. Sotomayor, again, talking about we've had no time to reflect. It's all been on a bare bones record. She goes through first to talk about why the Alien Enemies Act likely does not apply, and that the court's conclusions are suspect. She's talking about her brethren, her fellow judges. She said on page 5 of her dissent, the government's plan, it appeared, was to rush plaintiffs out of the country before a court could decide whether the president's invocation of the Alien Enemies Act was lawful, or whether these individuals were in fact members of Tren de Aragua. She then walks through the judge's order below, which she appreciates, Judge Boasberg. She also says, this is the second time this week. She points out, just as Judge Sotomayor on page 9, a second time this week that the court saw fit 5-4 again, with Roberts and with Roberts in dissent in that one, to vacate a temporary restraining order standing on its last legs. In other words, related to payment, cutting off grants to teachers under the Department of Education. In other words, you're in a TRO mode. Why are we in a TRO mode? We should be waiting for the preliminary injunction to be issued by the judge or not. After a fuller record, that's what we're supposed to do with the Supreme Court. Why are we interfering on a TRO with just hours to go left in a TRO? We should be more judicious in our use of our jurisdiction, is what she's saying there. She continues. On page 11, against the backdrop of the U.S. government's unprecedented deportation of dozens of immigrants to a foreign prison without due process, a majority of this court sees fit to vacate the district court's order. That's a problem. And she ends it with her respectful dissent. Kavanaugh, in his concurrence, says, we all agree, 9-0, due process. But the due process is by writ of habeas corpus, individualized, wherever they reside. What about the 250 that are in El Salvador? Ignored in the three paragraphs of Justice Roberts. Here's what just so you know, I'm not hiding it. Here's the actual opinion that constitutes the opinion of the court, per curiam. This matter, this is on page, it's only 3 pages. This matter concerns the detention and removal of Venezuelan nationals believed to be members of Tren de Aragua, an entity the State Department has designated as a foreign terrorist organization. 5 detainees and a putative class sought injunctive relief below against their removal. All right. We grant the application and we vacate the temporary restraining orders. Those are the ones by Boasberg. The detainees seek equitable relief against the implementation of the proclamation and against their removal under the AEA. They challenge the government's interpretation of the act and assert that they do not fall within the category of removable alien enemies. We don't have to reach those arguments now. Great. Thank you. Challenges to removal under the Alien Enemies Act, a statute which largely precludes judicial review, right, is only done by writ of habeas corpus. An immediate physical release is not the only remedy. Okay, so then they're saying that writ of habeas corpus has to take place in the jurisdiction of confinement, which is up to the Trump administration where they ultimately confine these people. Bottom of page 2. The detainees, the 5 guys, are confined in Texas, so venue is improper in the District of Columbia. As a result, the government is likely to succeed on the merits of its action. The detainees on page 3 here also sought an equitable relief against summary removal. They're saying, but you can attack and have judicial review about interpretation and the constitutionality of the act. Also, whether he's subject to the act. You can do that in writ of habeas corpus and your Fifth Amendment rights in Texas. Again, not a mention in the per curiam decision about the fate of the 250. Let me give you a quick what's going to happen next. Judge Boasberg was going to find the Trump administration any moment now in contempt for violating his order to have the planes grounded and not continue to fly to El Salvador, right? And that they continued to fly it, but is a violation of his order. The question is, now that the order has been effectively invalidated, that he's not the right court, D.C., that it should have only been done in Texas. I think all things have to stop now in front of Judge Boasberg. I think he just lost his right to do contempt. He just lost his jurisdiction by this order. Similarly, Judge Zinnes in Maryland, her order that forces Abrego Garcia, who was illicitly sent to El Salvador over an order of protection with a green card in his back pocket, and her order to bring him back, I don't think they're going to support that either, but we're going to see after full briefing is completed today. Based on this new ruling, I think it looks terribly dim for Abrego Garcia. Now, they might try to do a make good and a make up and go, well, those 250, but this guy's different because he should never have been sent there. But they'll probably say, we can't order him to come back. He's sorry. He's outside of our jurisdiction. There's nothing we can do. There's nothing that judge could do. That's where I think they're going to end up. I'll continue to report on it right here. Run right back here. About every 2 hours today, there's going to be an update in this case, and I'll bring it to you on Legal AF. I'm glad you're here with us. I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.